everyone. Welcome to another exciting live stream with immigrationquestion.com. My name is Maliha and I'll be your host for today's session. Today's topic is one that hits home for many individuals and families. It can be extremely frustrating having to spend months gathering documents, preparing for your interview, and dreaming of opportunities that await you in the United States, only to hear these dreaded words: your visa application has been denied. In fact, beyond frustrating, it's heartbreaking. But here is the thing: not all denials are the end of the road. Our topic for today is overcoming US visa denials and understanding your options. It was thoughtfully curated to guide us in overcoming these heartbreaking denials and provide strategies, legal remedies, and second chances to turn things around. Joining us in this session is someone who knows this process inside and out. He's a seasoned attorney with decades of experience in immigration law and the founder of John W. Lawit LLC in Ewing, Texas. He has also served as an immigration judge and taught immigration law at the University of New Mexico and Texas Tech University. Join me in welcoming attorney John W. Lowett. Welcome, Mr. Attorney Lowett. We're excited to have you again on our live stream.
Thank you, Malia. I wanted to
Thank
begin today's discussion by going over basic grounds of inadmissibility, because inadmissibility is a concept that prevents people from immigrating to the United States or sometimes even entering the United States. And almost all of the grounds of inadmissibility we're going to discuss have a corollary as a ground of removal. And the basic difference between removal and inadmissibility is removal happens to people that are already in the United States. Inadmissibility has to do with people coming to the United States. And so if you're inadmissible, you may not be able to get a visa and you can't get across the border. If you're being removed, you're already in the United States, and the Department of Homeland Security believes that you've committed acts that make you inadmissible to the U.S., and so they convene a hearing called a removal hearing. And in the removal hearing, the judge considers the grounds of removal that have led you to be in front of them. Of course, the most common ground of inadmissibility is entry without inspection. You're not admissible for hardly anything if you come in without inspection. But the grounds of inadmissibility are fairly specific. The first group are health-related grounds of inadmissibility. And that covers communicable diseases of public health significance. During COVID, the health-related grounds of inadmissibility became as important as the criminal grounds of inadmissibility. So if you have a communicable disease that's of public health significance, you can not be allowed into the U.S. If you don't get required vaccinations, you may not be allowed in or may not be able to immigrate. If you have a physical or mental disorder that has caused you to engage in harmful behavior, you may not be admissible to the U.S. And if you're a drug abuser or addict, you may never be admitted to the United States. Now, there's the other big group of people who are subject to removal and are inadmissible are people that have committed crimes. And there's a hierarchy of crimes. And the first one to talk about is crimes involving moral turpitude. Moral turpitude is a concept in law that says certain crimes are just evil just because of the mental state that the actor has to have to commit them. So, for example, theft is a crime of moral turpitude because it requires the mind of the actor to be engaged in a specific criminal behavior. And theft, fraud, these are all crimes of moral turpitude. And some of them are very serious. The next criminal ground that is very, very significant is controlled substance violations. With the exception of possession of a one-time occurrence of 1 ounce or less of marijuana, every other controlled substance violation makes you removable. Every single one. And even if you were arrested for the 1 ounce of marijuana, if you do not have a qualifying relative that is a permanent resident or U.S. citizen, spouse, or parent, you may not be able to get any forgiveness, even for the marijuana situation. Now, multiple criminal convictions is another ground. It's separate, and it involves people that have, generally speaking, done multiple crimes. And if you're convicted of multiple crimes, that's a separate ground of inadmissibility. Then there's drug trafficking. There is no forgiveness in U.S. immigration law for drug trafficking at any level. If you're a convicted drug trafficker, you will be removed from the United States and barred for life from coming back. Then there's human trafficking. If you're engaging in human trafficking, that will also result in a lifetime bar. Let's see. Then the next big group are security-related grounds. That includes espionage, sabotage, or terrorism. We should talk about terrorism. Terrorism is a very loose concept that is a function of the law of the moment, meaning that acts of terror are put into the immigration law, but they change all the time. And so if you're accused of being engaged in terrorism, or if you're convicted of engaging in terrorism, or if the government has reason to believe you've engaged in terrorism, you are going to be barred from the United States. There is no forgiveness for people involved in terrorism. Even aiding and abetting terrorists will result in a lifetime bar. There have been several cases where people fixed the cars of people who were members of terrorist organizations, and they had no idea about the person's political affiliation. They were just fixing their car. And those people are barred for life because they're giving comfort and support to terrorism. And so this is very, very serious. The other area of activity that can result in removal is immigration fraud. Immigration fraud meaning you lied on one of your applications, or you hid something from the government so that it was impossible for them to know the true facts about you. And visa fraud is also a ground of inadmissibility, and it's also a ground of removability. And so all the grounds I've just gone over as inadmissibility have corollaries in the removal context. The other thing that is not here is a ground of inadmissibility is aliens in possession of weapons that they're not allowed to possess. The Bureau of Alcohol, Tobacco, and Firearms is the agency that enforces the rules regarding who can and cannot own a weapon in the United States. And in many cases, people who are here on student visas or on temporary worker visas want to go out to the gun range and shoot. Now that's fine, but they can't own the weapon that they're shooting. There's no law against target practice. The law is about possessing the weapon itself, and in some cases possessing the ammunition itself. And so weapons are a whole nother ball of wax that can land you in immigration court and also result you not being able to come into the U.S. Now, Congress has decided that in certain circumstances there can be forgiveness, and that's where we get into waivers. And only certain things can be waived, but it's really quite extensive about getting waivers in terms of the eligibility criteria. In general, to qualify for a waiver, a person has to have a qualifying relative in the United States. That could be, in certain circumstances, a U.S. citizen child. It could be a permanent resident spouse, or permanent resident or U.S. citizen relative who would be eligible to help you qualify for the waiver. Each of the waivers is slightly different. Perhaps the broadest of all waivers, and this may be the most important one, is what's called a 212D3 waiver. The 212D3 waiver is a non-immigrant visa waiver that allows a person to enter the United States after they have committed a deportable offense or an offense that makes them inadmissibility to the United States. That's called a 212D3 waiver. It is the broadest waiver that exists in U.S. immigration law. It only affects non-immigrants. It is not for immigrants. Immigrants have their own set of waivers. But you can get waivers through 212D3 for criminal convictions, for being convicted of possession of 30 grams or less of marijuana, and some multiple convictions. That would come under a 212D3 waiver. The health-related grounds, they also can come under a 212D3 waiver if the person has a religious problem with having waivers at all. I mean, taking vaccinations at all. And it is possible for religious reasons to get exemptions from the health-related grounds, at least in this non-immigrant context. What the 212D3 waiver cannot waive are security and related grounds of inadmissibility. There's no exceptions for that at all, and so that's not gonna work. International child abduction also can be waived under certain circumstances. The membership, there also is a waiver if you were a member of a totalitarian party at one time in your life and you're no longer involved in it. These waivers are really, really broad. About the only thing that can't be waived is terrorist acts. Almost everything else can be waived in the non-immigrant context. Now, it's a discretionary waiver, and there's really no form that's used to file for it. What happens is the person goes to let's say the person had been convicted of something small, like a petty theft at a Walmart, for example. If they were convicted of petty theft at Walmart, that's a very minor kind of thing. And what happens is you go to your interview and there's an application that's filled out called a DS-160. And that application covers all the grounds of inadmissibility that might apply to a particular applicant. And so the way it works is you go to the interview, you're found inadmissible by the consular officer. And then the consular officer can recommend the waiver. Now, if the consular officer, the only agency that can grant waivers, by the way, is USCIS. The State Department does not grant waivers. Only USCIS does. But they work hand in hand with each other. So the consular officer decides you're inadmissible because of the shoplifting conviction. And you say, well, look, I've got my children are adults. They're living there. My daughter's about to get married. I really want a tourist visa to be able to go in and to attend the wedding. If the consular officer recommends the waiver, an application is then submitted to USCIS, and they generally rubber stamp what the consular officer wants. So because USCIS is not interviewing the person, there's no in-person interview in a waiver application. And so if the consular officer conducted an interview at the consular office, that would certainly be where the waiver issue would come up. They're granted sometimes in very extreme situations. I'll give you an extreme example. I had a client who had been convicted of possession and distribution of multiple times for heroin in Canada. I mean, multiple times. He's barred for life from immigrating to the United States. Well, what this gentleman did was he wanted a waiver because he was in a PhD program in the United States that would train him on how to work with drug addicts and how to assess the medical assessment of drug addicts, everything having to do with it. He was working on his PhD program. They gave him the waiver. every year he had to go back to back to the port of entry and apply for the waiver again because the government wanted to keep their eyes on the guy to make sure that he was actually doing what he said he was going to do. But there's a situation where major drug trafficking convictions had already occurred and the person was able to come in on a non-immigrant waiver. That's an extreme example, but I'm trying to convey to you that these are very broad. And just because you can't enter the United States doesn't mean you can't qualify for a 212D3 waiver if you're applying for a non-immigrant visa. It's very, very important that you understand that there's a distinction between waivers like this and waivers that bar people for the rest of their lives. Now, now we'll talk about the waivers on the immigrant side of things. And so there are waivers for the health-related grounds. I mentioned that previously. And then there are specific conditions that have to be met if you've got a health-related inadmissibility issue. And generally speaking, if you comply with what the government is requesting, for example, if there's an alternative way for you to take medication that would prevent you from having a communicable disease that might be dangerous to the public, they can waive the requirement that you get vaccinations if there's another way to do it. In certain vaccination situations, however, in particular, having to do with the pandemic, if you didn't get the vaccination, you don't immigrate. It's that simple. But of course, the pandemic's an extreme example. It's as extreme as it gets. And so the health-related inadmissibility around the pandemic was very, very strict. Now, there's criminal offenses for which you can get waivers too. For one of them, the first thing is when you do go to the waiver, you have to show rehabilitation. You have to be able to demonstrate that you are a changed person and have concrete proof that you're a changed person from the person who committed the crime. The other factor is the longer it's been since the criminal conviction, the more likely it is that you will be able to obtain a waiver of the criminal grounds. And of course, if you have relatives in the United States, that's absolutely critical because they're not going to grant the waiver unless there is family reunification possible in the US. So you have to have a qualifying relative. Now, another waiver that we should talk about is unlawful presence waivers. Unlawful presence is a situation where you're not in the United States legally. That is, you either crashed across the border, or if you didn't crash across the border, your visa expired and you began to accrue unlawful presence. Once you accrue 180 days of unlawful presence, if you leave the United States, you're barred for 3 years from coming back. If you've been unlawfully present for a year or more, you are barred for 10 years from coming back. However, if you are married to a U.S. citizen or permanent resident, or you have a U.S. citizen or permanent resident parent, you can get a waiver for the unlawful presence. The significance of that is, if you go to the consulate for your immigrant visa appointment and you're carrying that approved waiver with you and you have no other grounds of inadmissibility, they can admit you into the United States because the waiver has been granted. If you don't have the waiver in advance, when you go to your visa appointment, you can still submit the waiver after the visa appointment, but you'll be stuck out of the country for several years because it's taking almost 2 years for waivers to be approved on the immigrant side by USCIS. So that's very, very important because that affects thousands of people who are trying to immigrate to the United States who have been here illegally for some time. If there's any other ground of inadmissibility, you cannot get that unlawful presence waiver before leaving the U.S. Very important. Because if you have another ground of inadmissibility, the State Department will disregard the waiver you have. So that's a very good part of the law that allows families to stay together and doesn't break them up for years. Now, fraud and misrepresentation is a very common thing at the consulate, before USCIS, and at the border. And there are waivers for that, for fraud and misrepresentation, if you have a qualifying relative and at least 5 years have passed since you were removed from, or since you left the United States. their membership in a totalitarian party can also be waived if you can show that the membership was not voluntary. For example, it used to be in the People's Republic of China that every young boy and girl had to join a youth organization that was an arm of the Chinese government. And so as a result, they had to pledge allegiance to communism. And so as a result, on the face of it, they're not admissible. But if they can show that in many cases they couldn't get a job unless they pledged allegiance to the communist state, they couldn't advance. There's a lot of things that happen to them, but then they get out of China, and they're changed people. They're not involved with the party at all. And in fact, many of the youth members, once they were 18, they just stopped and went on with their lives. But the State Department regarded that as membership in the Communist Party. And so there had to be a waiver for them to be able to come in. Now, even alien smuggling, there's a waiver if it's an immediate family member that you smuggled. If you smuggled someone who's not an immediate family member, though, it's a lifetime bar. Let's see.
Thank you so much for the valuable insights, Mr. Lowett. That's incredibly helpful. I think we have questions coming in live. We have a question from Mr. Juma, if you'd like to address it. It says, I was arrested a long time ago, but the charges were dropped. Could that still cause me problem while my immigration with my immigration application?
Well, in general, if you're not convicted, I don't want to use the word dropped. I don't know what that means, but if you're not convicted, you can't be found inadmissible because of the crime. There's an exception to that, and that's for drug trafficking. With drug trafficking, they only have to have reason to believe you're a drug trafficker. You don't even have to be convicted. And of course, there's almost no immigrant waiver for drug traffickers. But generally speaking, it should not be a problem. Now, if you are in the U.S. and you're going to adjust your status, you're going to go to a consulate, you have to be sure to bring the arresting officer's report and a certified copy of the disposition. Because just being arrested is not a ground of inadmissibility or deportability. It's being convicted. And so if the charges were dropped and you were not convicted, as long as you give them all of the documentation and everything, it should not affect you at all.
Absolutely. That's really, really insightful of you, Mr. Lowett. We have another question coming from Mr. Daudu. I have a health issue and I'm very worried it might take me as an inadmissible. Is there any way I can still apply for visa or green card?
Well, I don't know what the health issue is, so it's very hard for me to answer the question directly. But in general, if there's a waiver for whatever your health issue is, and you follow the requirements to get that waiver, you should be able to apply for a visa or a green card. It just not knowing what the health issue is, it's very hard for me to discuss it in any more detail than that. But in many, many cases, you can get forgiven for health issues. After all, they're not your fault, generally speaking. You just get them.
Thank you so much. That was very insightful of you, Mr. Lowett. Moving on to our next question from Mr. Charles. If my US citizen child petitions for me, will my past immigration issues like entering the country illegally make it impossible for me to stay?
If you did not enter the country legally at one time, and you have a U.S. citizen child, the child has to be 21 years old, petitions for you, you will have to get your visa abroad. You will not be able to get your visa in the U.S. Now, I don't know what the past immigration issues are. If you entered illegally, you can certainly be forgiven for that. And so if your past immigration issues, you either entered illegally or you overstayed, it is possible to get waivers. Now, the only thing is that if you're going to get an unlawful presence waiver, your children cannot be the petitioners. It has to be a spouse or parent who's a U.S. citizen or permanent resident. In almost all other waiver categories, your U.S. citizen child can be the qualifying relative to allow you to get the waiver, except in the unlawful presence context.
Absolutely, that was very helpful, Mr. Lowit. Moving on to our next question from Mr. Benedict. I received a notice to appear, NTA. What should I expect at the hearing and how can I prepare?
Well, the NTA is the formal document that advises a person why the U.S. government thinks they're inadmissible to the United States. It's a document that is given out. It has information about the person, how they entered the United States, and then they allege the ground of removability, whatever it might be. Now, when you get to immigration court, there's two levels. The first thing is your first hearing is called a master calendar hearing. And the master calendar hearing is very much like a criminal arraignment. It's informal. The judge wants to know, are you going to contest the grounds of removability? Are you going to be applying for any kind of relief? Are you fearing persecution? Are you going to apply for political asylum? And you tell the judge, well, judge, we're going to do this, or we're going to apply for that. And so then the judge can make the decision about scheduling you for the individual hearing. The individual hearing is where there's an actual trial. The government puts on its case, and you, as the subject of the notice to appear, get to put on any defense that you have, as well as if you submit petitions that might allow you to immigrate, the court may not want to move forward with your removal and let those petitions go through. For example, if you're married to a U.S. citizen, the U.S. citizen files for you, and if that petition was approved, it would affect your ability to remain in the United States, the courts will generally wait and let that petition go through. However, if you don't have any form of relief, even at the master calendar hearing, unless you identify a form of relief you're going to apply for, the judge has the power to enter an order of removal immediately, even in the preliminary stages of the removal at the master calendar hearing. As far as the individual hearing is concerned, first of all, the likelihood of you succeeding without an attorney in immigration court is very, very small. However, there's usually a great deal of legal complexity in presenting a proper removal defense. And so it has to be prepared, it has to be documented, and you have to file it with the court as quickly as you can.
I totally agree with that, Mr. Lowit. Totally agree. Moving on to our next question from MBU2. I've been living in the United States without papers and now I want to apply for a green card. Can I apply for a waiver for unlawful presence so I don't have to leave?
If you have a U.S. citizen or permanent resident, spouse, or parent, you can get an unlawful presence waiver. However, and of course, it would be very important because if you are going to apply for the waiver, it has to be attached to some sort of application for permanent residence. So you would have to have somebody who would be able to apply for the waiver for you, and you could get your unlawful presence taken care of, but you will have to go out of the country to get your visa in the end.
Absolutely, totally agree with that, Mr. Lovett. Like you previously explained very deeply about this topic in the beginning of the session. If anyone would like to go and replay it, we are available on Spotify. We also have our recorded sessions in YouTube. So you could go and replay the session where Mr. Lovett explains very deeply about the question that Mr. Mbutu just had. Well, this was the last question as we were not able to take more questions because we are running out of time. But if we have anyone who are still having more questions, we would love to address as many as possible. You can call us on 516-703 and 3483. We could connect you to the same attorney whom you would be willing to contact with. And that's it for today. It's a wrap. Thank you so much for joining us. A
It
special
was
thank you to
my
our
pleasure.
guest. A special thank you to you, sir. It was great having a word with you. Thank you for your time, for your expertise. We look really forward to having you back on the show again.
It'd be my pleasure to come back.
It's our honor to have you here in this show. We hope this webinar answered some of pressing questions on overcoming US visa denials and understanding your option. Visit our website at immigrationquestion.com and connect with experienced immigration attorneys who can guide you through your unique situation. If you missed any part of this session, like I mentioned before, or would like to listen again, the live streaming is being recorded and will be live for listening on Spotify. Simply search Portalist Talk by immigrationquestion.com and listen to today's session and previous ones on the go. See you at our next session at the same time, same platforms. Once again, thank you for being on the session today, Mr. Lawit. It was indeed an insightful session. All thanks to you. We look forward to having you again.
Thank you.
Thank you so much. Have a great noon, everyone. So, see you next week. Stay informed and empowered through your immigration journey.